Thank you for taking the time out and to join this webinar on a Saturday. Um, I'll be very honest. When the bill was introduced before the Parliament of India, my first reaction was, "Oh, this is the fifth iteration of the bill. It'll probably get referred to the parliamentary committee. There'll be a series of consultations. It's not likely to become a law anytime soon." But the pace at which the bill was enacted and now we have a law speaks volumes about the political will of the central government to bring in a comprehensive legislation like the EU GDPR. Today we'll be discussing some of the provisions of the bill, and not just the provisions. Basically, what are the consequences and ramifications of those provisions, what organizations need to do and what they need to be mindful of in terms of their legal requirements and obligations. So to kick off today's session, if I may just ask Abha and Kanishk to share some of their initial thoughts on this new law that we have now.
Hi,
Abha, if I
Lagna.
can, yeah, yeah, hi.
Hey, Lagna. Thank you so much. Thank you so much for having us here. And it is, great. I look forward to having a very insightful session today. Lagna, as you were talking about it, with this bill coming in for the fifth time, the whole of the country was, sort of glued to watching the parliamentary session. And we were seeing whether this bill is likely to pass through this time or not. Because over the previous years, we've been like, this monsoon session, it is going to be, placed and it'll pass through. And then suddenly we had this thing that, no, it's been withdrawn. And then, we were back to where we had started. In terms of privacy and thinking out loud when the whole bill became an act, if you look back, technically this discussion started back in 1950s, right? Just few years after we got independence. So the first case that went to the Supreme Court was Kharak Singh versus State of Uttar Pradesh. And there was a dissenting opinion. Justice Subbarao said that, privacy is inherent part of right to life. But then this was a dissenting opinion, which obviously had found its place in the Puttaswamy judgment. Finally, over the years, like from Kharak Singh to MP Satish Chandra and that matter, and then we had 2017 where the whole judgment was deliberated upon, and then this historic judgment was pronounced, and we had the Supreme Court saying that all right, there has to be right to privacy has to be codified, so there has to be a law around this, and the central government was directed to bring about this law. We have seen through various bills, like almost 6 years, committee reports, bills, and finally this becomes the act. There are certain fundamental facets which, like you've rightly mentioned, talk of the political will of the country. And like we always say that we are a growing economy. In this economy, we cannot kill, we cannot choose to kill innovation in name of privacy. We cannot stifle research and development. So, just as we open this bill, there's a very interesting statement. It says that while we stand to safeguard the personal data and right to privacy of the citizens, at the same time, it must also be allowed to be processed, to be lawfully processed by the organization. And that's where the beauty of the bill starts, right from changing it from he, which our acts have always referred to he, and similar acronyms. This goes on to say she. We see there are exceptions, and this is, I believe, one of those only acts across jurisdictions where duty has been cast upon data principals too, who are supposed to be acting in good faith. We're not only talking about penalties. So in a way, it is not such that it can create imbalance. And then one more subject which particularly I find quite interesting, and this is the exemptions that are given. And there's a lot of discussions. We will actually eventually have to see how these exemptions have worked out. Over the many years, even when we did not have one law governing us, we did have something starting from IT Act, and then those rules that had come up around 2011. This whole act, when we talk about exemptions, many of them have already been pronounced in the judicial activism or judicial pronouncement over a period of time. If you look at jurisdictions, like we keep quoting GDPR provides this and that is the gold standard. But it wouldn't be out of place to say that when the national security stands threatened, when it is the question of integrity of the nation, there are laws that come up overnight. So if unless there are exemptions crafted, unless there are judicial oversight placed in effect, I think it'll be too early to say that there is an imbalance. On a concluding note, I would say that this act creates a balance. It's a very good beginning. We have to look forward to how the delegated legislation works, how the rules come up for further development, dwelling into the subject.
Right. Thank you so much, Abha. I mean, those are some great thoughts and I mean, I really like how you differentiated between the right to privacy and data protection because they are actually distinct concepts. Kanishk, if you can just chime in here and share some of your initial thoughts on this new law.
I think this law is just at the right time, given a lot has been happening, particularly around how data breaches have been impacting. We had seen that large number of companies in India had suffered massive data breaches, and they were not even reporting these breaches to certain, forget informing the customers. So there was no sense of responsibility. There was no disclosures that were happening. And most of the times when disclosures are happening, we were finding out that these disclosures were being reported by media houses saying, okay, this company lost this much amount of data. And then users are like, okay, I had my data stored with this company. My credit card information was probably stored by this company. They didn't even provide me any kind of notifications, right? So the other part, which was a big concern, was that a lot of companies were collating data, and this data was shared with third parties who were processing this information on, were using it for various purposes, including marketing, applying data science, right? So those things were creating a lot of havoc in the country. Now, with the personal data protection bill, companies have to build in processes to safeguard user data, obtain consent, and also inform the users about what are they going to use, what technology are they going to use, some monitoring tool for monitoring customer data, or even if what kind of processing mechanism are they. So obtaining consent, that's going to be there. And the good part about this bill is there is no criminal liability against companies. The bill is purely has financial liabilities for companies which are up to 250 crore rupees. So there is no criminal liability. So far, we have seen other laws. There have been criminal liabilities introduced, whether it was significant social intermediary guidelines which came into the picture. So this should be taken up in the right spirit, right? And a lot of people were putting questions that this makes the government more powerful. The government will never bring any law which makes them less powerful. The laws will always in a direction which gives more power to the government. It's more about regulating, getting more mechanisms for governing the country. No bill will ever get passed in the parliament which will make the government less powerful. So those are things which have to be understood. With respect to some of the work that companies need to do, I think government bodies will not be exempted. It is only going to be certain key government organizations which are into lawful interceptions or national security. They will get exemptions. Otherwise, large custodians of data, whether it is government or private organizations, they will have to comply to the law. And it's a great start point. Uh, it also creates a roadmap for the Digital India Act to follow, particularly to manage the non-personal data, which is also of a big concern. Right? So the time is just right, and there's a lot that could be done. So far, everyone has been talking about GDPR, European data protection regulation, UK data protection regulations, or California data protection. But today, due to this, I think companies will also create mechanisms to host data in India, have certain amount of localization of personal identifiable information of citizens, obtain consent. So it's a good start point.
Right, right. Thank you so much, Kanishk. Abha, if I may just ask you, Kanishk said that how this new legislation comes into and how it's going to set up the future of.
Lagna, I lost you. I cannot
Sorry.
hear you.
Yeah, can you hear me now?
Yes.
Yeah. So Kanishk talked about, the obligation on data fiduciaries to obtain consent, and as the law says, consent under the DPDP Act has to be free, specific, informed, unconditional, and unambiguous, which is very different from the SCBI rules, which sort of put in place more of an opt-out regime. So, how do you think, in terms of compliance, how do you think organizations should approach, the whole process of providing notice?
I've lost you again, Lagna.
Okay. No, my question was, how do you think organizations should approach compliance
Uh-huh.
where consent is the ground for processing personal data?
Yep. So this is a very interesting question. Thank you for that. And there's been a lot of discussion going around because so far, and again, referring back to GDPR, we have had various grounds of processing. Consent was just one of them. But if we look at this bill, consent is the biggest ground of processing. Then you have something called legitimate uses, and then there are a lot of conditions that are attached to this. Before I get into that, and gathering what I have been speaking with different colleagues in the industry, friends in the industry, and from a compliance standpoint, what has been happening is the fact that we have never had, or while we have had, but that was never enforced. At the moment, most of the organizations are sitting on tons and tons of data. And this data, and a lot of this data is personal data, right? Because we're not wired to so far, we have not been trained to so far to identify. How do you identify what is personal data? The definition is fairly broad. Anything that can identify a person becomes a personal data. How do you identify that? Believe it that yet certain organizations, even after training, even after sharing or sensitizing them, the question comes back: am I processing personal data? I have spoken to a vendor because I need some support, because I need some service. I have not processed personal data because my official email ID, does it amount to personal data? And these are practical challenges. We have CCTVs all over the place. We have had we have some regulations, we have some case laws. But did we actually look at when we put up CCTV, what specifications does the CCTV have? Is it a real-time monitoring? Is there somebody who's recording this data, or is it something which has the capability of processing biometric data, right? So at the first place, before, and a lot of organizations are trying to say, how can I be in compliant of this act? Before you be in compliant of this act, as simple as your educational institutions, we process a lot of data. Please try and identify what are the data flows of your organization, or what is your existing situation in terms of personal data. How much of data do you store at the moment? At how much of, and there is this again interface with the processing that is undertaken by the legacy systems, and the processing that are likely to be undertaken by the products or services that will be bought subsequently. So if you bifurcate all of them, the first point is to take stock of the situation where you are in terms of personal data. So this is something that will help you draw a funnel in the sense that you will know your data points, how they enter the organization. You map it with the purpose, you map it with the functions, you map it with how long they're stored in the system, who are the parties that they are shared with. And trust me on this, a lot of data that is coming in the system or flowing out of the system will get minimized. Once this funnel is drawn, once this funnel is put in place, the next step would be also to evaluate what laws apply to this. Because now we are at a situation where there is a likelihood that there are multiple privacy regulations that might end up applying to this data. So rationalize those regulations that apply to the data that you are collecting, and what are the rights and obligations with reference to each of that data. I would say try and error on the side of caution. Take the strictest measures. It also has consequences in terms of cost, in terms of practice, in terms of systems, in terms of training and awareness sessions and all of that. But if you look at the penalties that this act is throwing up, the penalties are huge. And if it is limited in the sense of, I'm not getting into the risk part of it, limited to the compliance part of it, it is huge. The penalties are huge. And therefore, having a stock of the situation, knowing where we are at the moment will go a long way in complying with this. So once you know this, then you can put in place all other. So if data subjects have to exercise a right, or those grievance redressal mechanisms have to be built in, that can be done.
No, that's very interesting. I mean, you talk about building a funnel that is sort of, help organizations in figuring out, how to map the personal data that's been collected, stored, retained, or, which should be raised and should not be retained in future. And what's interesting about the law is it actually allows data fiduciaries to sort of continue processing personal data and to give notice as soon as reasonably practicable, for the personal data that they have collected in the past before the bill became a law. Um, uh, I think my next question will be to both of you. I mean, a step forward from what is personal data to obligations of data fiduciaries. Kanishk and Abha, both of you. Uh, do you think that the law is clear on who is a data fiduciary? Or do you think there's a gray area between data processors and data fiduciaries, especially when we talk about cloud service providers? Because be it, enterprises or individuals, all of us, at some point or the other in cloud services. Uh, and maybe if you could, give maybe an example or two on, this gray area when a data processor may become a data fiduciary based on, how they collect, process, and store data.
Yes, see, a lot of time cloud service providers, apart from providing hosting services, provide other services by themselves, right? Uh, so the whole definition, whether they are a data processor or a data fiduciary, depends on how they are operating. Let's take the example of, say, Google, right? Say Google today is providing cloud services. Now, apart from cloud services, they also would provide certain security services which are bundled to their partners, right? And which would require them to capture all of this information, analyze all of this data, right? Since they're doing it as a service on top of what they are providing, that is hosting, their definition would be of a data fiduciary, right? As is being provided. Now, if they start doing it on behalf of another third party, they would then be acting as a data processor. So depending on the kind of services the cloud service providers provide, one has to really, take a situation into account. Normally, what I've seen is that cloud service generally operate in a B2B environment and do not collect the information except for individual informations whose customer is required by the cloud service providers. But there are scenarios where there are value-added services which most of the cloud service providers are getting themselves into today. On those scenarios, they are acting as data fiduciaries. That's there. As far as the law is concerned, I think law is very clear. Data fiduciaries are businesses that define purpose as a means of processing data. So, in other parts of the world, they are called as data controllers, whose job is basically to use the data. And they decide what data is needed, how long it needs to be used for, and how it needs to be retained. Whereas data processors are those who are processing this data on behalf of a fiduciary, right? So depending on how a cloud service provider is acting, whose data they are hosting, what kind of services they are providing, the definition will apply.
Yeah. And if I may just add to this, Lagna, the ecosystem of a cloud service provider is fairly complex. Somebody is providing the infrastructure, somebody is providing the hosting support. And if you look at it, there are multiple layers of stakeholders, right? So let's take an example of what typically could go wrong in a cloud environment. And if I may also draw your attention that if you look at all major contracts of the cloud service providers, under the law currently that we have, it says that data fiduciary is somebody who's determining the purpose and means of processing, which is clear. So as long as you are determining the purpose and means of processing, you become the data fiduciary. All right. Now you outsource a part of processing to a third party, let's say the cloud service providers. As long as they're processing on your behalf, as long as the processing is happening on your behalf, They are the data processors. But the catch is this. If you look at the terms and conditions of the legitimate interest of the cloud service provider, number one. Number two, the probability of negotiating these agreements. Under the Act today, data fiduciary is responsible for the processing that happens, including by the processor. So let's say you've outsourced an activity. If there is a breach, you have two things. One, that will arise on a contractual front. If there is a breach, say you've said that technical and organizational measures have to be such and such, and they are not implemented by the data processor, you can go and keep debating upon from a contractual standpoint that there was a breach, etc. But as the data fiduciary towards the data subject and towards your data principal and towards the government, you continue to be responsible. Now let's transpose this in a cloud environment. One, what is your ability to negotiate these contracts, particularly when the data fiduciary does not have the same, I would say, capital size, financial need, and we are in, let's also not lose sight of the economy that we are in and the sort of A's that cloud service providers provide, the sort of scaling and the infrastructure that is provided by the cloud service provider. So mostly, and this is something that the European Union has already experienced. Your ability to negotiate your contract with them depends upon what commercials are going to place on the table. If the government comes upfront to say that, all right, we are willing to take the services and we are willing to build those guardrails where we hold the data processors to accountable should they overstep. Now, something which is as simple as, which says that I am going to use your data to improve my products and services. And if this data is not built around to say what sort of data, is it metadata? Is it data that is stored in the system? It could get very, very difficult to negotiate. So while under the law, the definitions are clear, but with the cloud service providers, it could get a bit tricky. We will have to wait and see how the law pans out, because somewhere I feel that the processors too have to be held accountable to the data that they process, and particularly if they overstep the contract, because then it becomes unfair to the data fiduciary.
Lagna, you're speaking on mute. You'll have to unmute yourself.
Oh, sorry. Those are very interesting thoughts, Abha. Thank you so much. If I may just request everyone in the audience, if they have any questions, they can just post them on the chat box and I'll take them up towards the end of the conversation. Abha, you talked about data breaches and how a lot of consequences that will arise out of data breaches would depend on the agreements that data fiduciaries have with data processors. Kanishk, if you can come in here and tell us a little bit about what sort of reasonable security standards can data fiduciaries employ so as to minimize their risks and to make sure that they are not held liable for conduct of data processors.
Thanks, Lagna. So let's start with the government organizations first, right? So the Computer Emergency Response Team has just recently come up with guidelines for government organizations to look at security, right? It's more like a baseline framework which they have created, and the government organizations have to implement it. So that's one good starting point for organizations to look at, more like a security framework to implement. If you look at private organizations, there are standards like ISO 27001, right, which is an information security management standard from an information security, data security perspective, which has also been emphasized the best practices, which in various guidelines which have come from RBI, NPCI, SEBI, right? Most of the regulators have been mandating organizations to comply to ISO 27001, get a certification. And if you don't get a certification, have certain processes mapped up to ISO 27001. Also conduct regular vulnerability assessment and penetration testing services. If you have third-party service providers, then carry out third-party, fourth-party risk assessment services, which are also covered as part of 27001. So that's there. The other part, from a baseline cybersecurity, could be carrying out a cybersecurity maturity assessment using, the CISF framework, which is developed by NIST, right? That's a good starting point. And today, government is also on the verge of creating a India-specific cybersecurity maturity model. Now, this is being worked specifically around the critical infrastructure. So, government will come out with a cybersecurity maturity model for critical infrastructure organizations to follow. So, once that comes out, that could is another, a good to have standard. But till the time it's not there, organizations can follow the NIST cybersecurity maturity model or the NIST CSF framework as a best practice to have. Those organizations who are not of great size, are not big enterprise organizations, they could use 27001 as a baseline. For startups, I think a lot of times they will have to choose service providers where security is built in as part of design. So if you're moving to a cloud service provider like a AWS or Google or Azure by Microsoft, security is bundled as part of those elements. So those are certain baseline, but companies must conduct some amount of security testing internally or using a third party to get certain level of assurance. That could be done by taking the list from certain. There are around 45 plus cert impaneled auditors. So those are some of the good starting point when you look at cybersecurity and data security.
Right. Thank you so much, Kanishk. And taking a step back from, and focusing on the wider scope of the law and not just on the cybersecurity obligations. Abha, if you can just, tell us your thoughts on what organizations need to keep in mind when they're designing a compliance framework or a compliance program in order to, keeping in mind these legal requirements and obligations that have been brought in place. What do you think they need to do? Where should they start? What are the, sort of checklist items they need to create? How
I
should they
lost you for the last 10 seconds again.
All right. Basically, I'm asking, if an organization wants to, initiate the process of complying with this new law, how should it proceed? What are those checklist items, or what are the, issues and pointers that they need to keep in mind when they decide to design their own compliance program?
Mm-hmm. So I would categorize that broadly in three headings, right? The first heading is that you need to be aware of what you're processing. And like in the first part of the discussion, we were talking about what is the data that we have at the moment in this system, what is the map of the data flow, something, there's this map of the data flow right from the time that it gets in the system to the time it is, maybe deleted, or maybe, depending upon if the data subject chooses to withdraw the consent, etc., but to the time the processing stops. So the whole life cycle of the data needs to be drawn in every organization, and this has to be done for every data that is flowing in the organization. As part of this, there will be, say, record of processing that will have to be created. And as you would see, that this act is more to prove accountability, which means that it is not sufficient to say that you have taken consent, but it is important to prove that the consent was taken, which was free, fair, unambiguous, clear, by an affirmative action. So a lot of time, Lagna, what happens is that when we talk about affirmative actions, when we talk about consent that is provable, we have moved out of that opt-out regime. We have moved out of where we say that this applies only to a certain set of data. No, it applies to all sort of data that flows in the organization. So first of all, what measures, and this is where both the technology and the legal minds have to speak together to say, how can they bring in, or how can they build up the framework in a way that the whole process of the data life cycle, right from the time that it gets into the system to the processing that it undergoes. And I will come to what happens when the data is shared with third parties, etc., or if the data subject chooses to exercise their rights, till the time the data is deleted from the system, right? Or if it has to be stored for defending or establishing a legal claim or otherwise, so that retention period is defined of that data. The second part is that no organization functions in isolation, right? So we always have lot of third parties. When I say third parties, these are your suppliers, these are your vendors who could be providing you as a basic as manpower, skilled manpower. So, a lot of them work on a model where a lot of manpower is provided for a short period or for a certain period where certain activity is conducted, or say projects are worked on, and there are different models around that, to where the data gets processed, where the data is outsourced for further processing. So again, the second part is that your vendor evaluation becomes very important. How do you carry out a vendor evaluation? Now, in a country where we are still in the process of developing, say, systems, developing processes, developing those best practices, which can demonstrate that these vendors or Lagna, the point is that it's not the question whether the breach will happen. The fact is, when will it happen and how prepared you are. Having said that, now you have vendors. What is your standard of evaluating them? It could be as simple as saying, and again, be mindful of the cost, because when you tell them that you have to be ISO certified, it has a cost to it. And not all vendors will be willing to get that certification. All right. If you go and audit, a lot of them will still come back and say, no, I have these audits going. I have got this audit. I have done this. I have done that. And trust me, from a practical experience, if you go and ask any vendor to provide you SOC 2 certificate, the privacy management certificate, it could be a tough task. There could be vulnerabilities there which the vendor would not be happy sharing it with you. Try and seek a summary of the audits that may have been conducted. Because one, and again, there have been multiple breaches. And I bring in an example of Marriott Hotel. It acquired Starwood, property of Starwood back in 2014. And then 2018, it suffered a breach. And then it was held responsible for a breach that happened in 2018 for a bug that was sitting in the system since 2016. So the link could be as weak as the point where your vendor or your vendor's systems are communicating with your systems. If that point is weak, there is a possibility that there could be movement of anti-social hackers or cyber attacks or anti-social elements laterally across the network, and the whole network would be compromised. So you have to be mindful of the vendors that you onboard, of the suppliers that you work with, and all of them has a lot of implications. It is easier said than done. And most importantly, I come to the human resources. So like I was sharing with you just when we started this discussion, human resources are they can help in preventing it. They can help in avoiding cyber attacks. They can help in avoiding breaches. And we have moved from a point where we had corporates, the networks were fenced, and everybody would go to office, work from office, so the network was fenced. Now we have moved to a situation of a lot of remote working off the network. Many a times, security patches are not updated, etc. I remind you of a situation, and our audience would be able to relate it somewhere around May 2021. We had this breach that had happened on a gasoline pipeline in United States, and then suddenly United States was out of gas. And how did that happen? This happened because we had this whole thing where VPNs were built, and then you could seek access to your corporate network. But then the passwords that were used at that point, there was this exposed password that was identified in a different breach, was used by the hackers, and they sort of got control, and apparently ransom was paid in order to recover from that situation. It was sort of a state emergency just because the password got compromised. What I wanted to share is that employees, the workforce, also includes subcontractors, anybody who's working on your tools, anybody who's working on your systems. They have a very strong role to play. But how much is too much? How well have they understood? And how well can you, so while somebody would say that, we have moved to a zero trust architecture, and, the devices are constantly verified, etc., and all that, I would still say that the strength or the weakness is still of the resources that you deploy. Because with these resources, you can safeguard your system, you can prevent major mishaps, or a law or say deviation of a second can cause irreparable damages.
Right. Thank you so much, Abha. Kanishk, if I can come back to you with the same question, you gave some very, some very excellent pointers and checklist items for cybersecurity, how to safeguard from cybersecurity breaches. But generally, when an organization is designing a compliance program, what are some of the, items or issues that they need to keep in mind?
So I think some of the baseline is to have certain security practices built in as part of design, which is called as security by design. Uh, as simple as having complex passwords and passwords getting changed in 15 days or in a month for the organizations, using encryption mechanisms for storing data, both data at rest and data in motion, having a baseline cyber defense in place, which could include having a firewall, an IDS, and IPS, a web application firewall to defend against any kind of cyber attacks, right? And all of this could be today be built in as part of service which you're obtaining from one of your service provider. And it could also be designed on the cloud. So if you're using Azure or AWS or Google or Oracle Cloud Services, a lot of these today get bundled where you would have IDS, IPS, and your antivirus services have today moved ahead in terms of threat monitoring services, which are offered, right? So people can opt in for some of these services. There's another aspect which is on information right management, right? So you can enable information right management, which is bundled as part of the services which you're operating from your cloud service provider or your hosting service provider. On email security, you can set up your email security correctly by having your DMARC and SPF records configured in the right way to avoid any kind of phishing attacks. You can also invest in further on email security by taking email security services from various service providers, including Microsoft, Google, or Amazon. They have services which are there. Some of these cloud service providing companies have also started providing security monitoring and threat intelligence services. So if you look at Microsoft, they have something called as Sentinel, which is for providing security monitoring services. They have Defender, uh, Purview. Some of these are security offerings which are there and you can pick and choose. And they are also come up with their own zero trust based model to safeguard the organizations. Companies like Google have acquired security companies like Mandiant, which offer this on cloud, which is there. So now Mandiant is part of Google Cloud. So if you're taking Google Cloud services, then Mandiant services could be bundled as part of the larger offerings to suggest. If there are startups, right, having somebody who's doing technical job but also understands security is going to be there. So aspects like secure coding, secure development, secure DevOps, best built up could help streamline the code. And before you take the code live, you could do beta level testing for that code. So those are some of the baseline security tactics which could be built up. And for software development, you can do black box, which is you have no knowledge of the network. You can do gray box where you have partial knowledge and you're trying to escalate privilege, and do white box where you can actually evaluate the code. So that's the level of testing that could be done, particularly for securing the organizations from any kind of cybersecurity breaches. So depending on what is the size of the organization, the way they are designing, all of this is get set up. Most of the organizations today are startups, and even including enterprises, are building their business on cloud. So cloud security is built in, but they just need to pay some additional fee charges for enabling it.
Right, right. Kanishk, I have a follow-up question. I mean, those are some very helpful and great points that you just mentioned. But in order to demonstrate compliance, companies obviously have to maintain and create and maintain records that they have actually taken these steps and measures. So for how long should they retain those records, and how should they go about creating and maintaining those records within the systems and all of that? I mean, if you could give some insight into that as well.
So the standard which I spoke about, ISO 27001, if an organization gets certified on 27001, it's a 3-year certification, but you have to renew it in year 2 and year 3. When you're doing that, you have to maintain reasonable level of security. The certain guideline which came in required organizations to retain data up to 5 years, right? That's there. Now, some of those aspects are for larger organizations, and the startups were exempted from it, we have seen. But when you're building some of these aspects, you have to ensure that that data is safely stored. You have encryption which is built in. So the best way probably I would say for maintaining backup or retaining data is to have cloud-based data backup. And it also helps you safeguard against ransomware because today there is encryption which is available on the cloud, right? Your data could be backed up on your OneDrive, which is provided by Microsoft or other cloud service providers have similarly backup services, and that entire data is encrypted. So you can have encrypted backup, and then you can also have multi-factor authentication enabled. You can create mirror images and store that data at multiple places. So even if you lose, say, one backup because of somewhere, there is another mirror which is created. The other way of safeguarding is to take offline backups, which is obviously a little costly and it is time cumbersome because you have to take backup on tapes or hard drives on servers, manage it, maintain it, and you require a specific IT person for doing it. Uh, those are some of the mechanisms. The certain guideline also talks about the keys for some of this data which is encrypted or stored. Having those keys safeguarded in India, maintained in India, which became a point of concern earlier. But the reason government wanted those keys to have local mirror images is that even if some of this data is backed up somewhere outside, and this data say is impacting critical infrastructure or national security, then there is some level of localization which is built in. There is a mirror which is created, and government can get access to that data. Because a lot of times we have seen that companies claim that they have backed up the data somewhere overseas and they were hit by a cyber attack or a ransomware, right? And they were not able to get the access of that kind of data. That's why government has specified some of these mechanisms. So the certain guidelines come into the effect in a big way. That's there. But as far as the overall security backup is concerned, I think cloud-based backup services are the best, and you can have multiple security layers built in as part of it. You can have cloud security access services built in. You can have controls defined. You can have encryption. You can do multi-factor authentication, right? Those are larger level of controls which could be deployed in cloud. And depending on the cloud service provider you're taking a public cloud or a private cloud or a hybrid cloud-based model. Different security techniques can be applied on top of it.
Right, right. Thanks, Kanishk. Abha, if I can come back to you for another question. This is regarding appointment of a DPO, which is an obligation under the new law. Who do you think would be the right person within an organization? Should it be an internal candidate? Should it be the CIO team? Because a lot of organizations, I'm not sure if
Again.
you're ready to tell me or not. A lot of organizations already have CISOs appointed. So, do you think this is something the DPO obligation and responsibility should be given to a CISO? Would that be a wise decision, or do you think it should be somebody completely independent?
Yep. So, Lagna, this concept has finds place in Brazilian data protection laws, GDPR, and I think few other jurisdictions. Who's a DPO? The qualifications of the DPO is not defined in most of the regulation. I've not seen qualifications of the DPO being defined. But one thing is, two things rather are clear. One, the independence of the role. Two, their ability to protect and safeguard the rights of data subjects. So they are the ones who are answerable to the board if you look at it from a GDPR or Brazilian data protection point of view. The larger question here is, and the question that you've raised, who should be the DPO? Now, I see it differently. So is it somebody who could be just somebody who must have basic skills and understanding of the privacy law, which is fundamental, which is required, right? But then, is it somebody who must be from, say, information technology domain? Somebody who should be a lawyer, and let's all agree that these are two domains at two end of the spectrum, right? So there's it could require a lot of perseverance for a lawyer to talk like a security expert and for a security expert to talk like a lawyer, right? So who should be appointed? The only answer is somebody who can safeguard, stand with the right of the data subject when it comes to upholding privacy. And why do we say that? Because privacy aligns with your right to life with dignity. So, like I always say this, It is possible for you to recover from many other losses, but it may not be possible for you to recover if there is a damage to right to life, an extension of which, of course, happens to be right to privacy. The second part that I see to this on the question of appointment of DPO is the independence of the DPO. And that is why in lot of jurisdiction, including the one that we have with us, it clearly says it is somebody who's reporting to the board. It's not to create a certain level of seniority. It is more to create that independence, that the DPO should be able to voice out concerns should they choose to disagree with all other departments, including the information security department, all the legal department, or any other operational administrative department. Right? So if you say CISO should be the right person, somebody, again, I go back to principles of, back to the law, principles of natural justice. You cannot be making the laws and you cannot be judging yourself, right? So going back to that, it is somebody who's independent of deciding the purpose or means or processes. It is somebody who can independently advise different bodies, who can independently adjudicate on, and most importantly, differ if they feel that it is not appropriate. And this is why, this is one of the reasons why, if you look at GDPR again, they have clearly written down in the law that you cannot dismiss the DPO for discharging the duties of the DPO, because DPO is seen as the semi-regulator sitting within your organization, somebody who can help you comply with the privacy laws. But because the opinions, or because there is a difference of opinion, you cannot choose to dismiss the DPO, right? So again, somebody who's able to appreciate the right and who's able to create that balance between the business processes with other departments of the organization, and somebody who can make sure that the whole gamut of right to privacy stands protected.
Right. Thanks, Abha. I also want to get your thoughts on, there's a lot that's been talked about and written about about generative AI and how that is sort of going to transform industries as we know of it. How do you think this law is going to affect the growth of generative AI, especially in India?
Yep. Yep. So I think somewhere around fag end of 2022, right before when ChatGPT got launched, and there was this, we were in another level of technological, situation where there was this, you don't need Google anymore, because you could just type your question and ChatGPT is going to help you. And then we had seen all those, ChatGPT can pass so many exams, ChatGPT can do this, ChatGPT could do a lot of it. What was one thing, and particularly when we talk about generative AIs, AI has been there for more than a decade, for more than many decades, 50 odd years. But when we talk about generative AI and the risk that I see associated with it, number one, from a privacy standpoint, we are talking about taking consent of people and then processing this data. Now, with all these models coming up, the scale at which scrolling or crawling of the data, scraping of the data is happening from the internet, a lot of processing of personal data is being done without the knowledge and consent of the people whose data is being scraped. So first of all, the first violation lies there itself. The second violation is that depending upon these data sets or the sort of data which is used for training these models, it has been universally accepted that there are biases that creep in the system, and these biases will be reflected on the output or when these models are deployed for decision making. Now, if I again go back, we have seen, so there are multiple instances that are available, multiple case studies that are available, so that these sort of tools, these sort of technologies, when they are trained on certain data set or when they are trained in the usual day-to-day life of people, we have, that lot of, so there was this thing which said that you can use these tools to screen CVs. You can use these tools for the purpose of identifying who could be the right fit for your organization. Let's understand this, that these tools, these data sets, or these technologies have had the have in the past, in the case studies, and currently as it goes, biases have been observed. Data have, AI models have shown hallucination. So they throw off data which is entirely different, which is not even which is absolutely false. Now, if these tools or these sort of deployments are done into or integrated with the technological setup of an organization, the amount of damage that can result by usage or deployment of this data set could be, because this could end up polluting the whole environment, whole informational environment that is there around us, right? The second part is that quite recently we had something where there was this case law where we're talking about an art that wins a contest, and that art is generated by AI, right? The debate is, the ethical debate is, should that even find a place in the art museum? Who has the right over this sort of product? The only case that I remember was when Google started putting up certain paragraphs, particularly, so in order to demonstrate the book. So when you Google up a certain book, you get a certain paragraph, and you will be directed that, all right, this is a book, but you don't end up getting the whole content. With this sort of scraping that is happening, isn't there is a violation of copyright in addition to violation of privacy, right? And then the data that gets processed in these tools and these systems can have severe to irreparable impact if they are put to use. So randomly, beginning from the time that I have taken the data, I am processing this data, but I've never told you that I'm going to process this data on a machine learning program, on a tool that I'm building in. If you choose to excise your right of erasure, or if you choose to excise, you withdraw your consent, how am I supposed to be facilitating this? So there are a lot of legal constraints, there are a lot of technical constraints, and there are a lot of ethical questions around generative AI, around deployment of AI and AI-based tools in our day-to-day operations.
Right. Kanishk, if I may ask you to chime in here and maybe speak a little bit about, so the law basically requires that every data principal who is affected by any data breach has to be informed, has to be intimated, although the form and manner of intimation will be described later. How does any organization, proceed with this task? For instance, if there are millions of data principals were affected by a data breach, what would be the manner in which notifications or intimations can be given?
So I think first and foremost is through an email. If you look at how GDPR came into the picture, the big change was the organizations when they were allowing customers to access their website or their mobile app, right? They started obtaining consent in terms of what kind of data has been captured, what kind of tools are getting deployed, what kind of techniques they are applying for using this data or monitoring, and the user can then accept, decline, or partially accept the policies, which could be as simple as the cookies policy of the organization. Depending on the data sets that have been collated by the organization and the level of information they have, they can inform the users. So if the organization has PII, personal identifiable information, then they could send out emails stating that an organization was hit by a data breach, and this has been the level of compromise, which could be losing a data processors, primarily information, credit card details, social security, health records, and what organization is looking at doing to secure it further. Right? That has been the typical response, right? And they will also inform that they have informed the regulatory body, which is the Data Protection Board, and they will be following the guidelines which the government has mandated for them, which could be penalties or fines and whatsoever. Right? That could be one way of informing. So the way you obtain consent, depending on the kind of data that has been captured, right? Uh, Companies can decide what level of information they want to give to the users. But normally what I've seen that when organizations have personal identifiable information stored, transmitted, or being processed by third parties, they send out full information stating, okay, we had all of your PII and we have lost it, and we will be doing these 3 steps to either recover or safeguard your data, or if the users need to take any step further, which could be, say, example, change their passwords, build out enhanced security controls, or build out techniques to avoid data leakage, could be using multi-factor authentication techniques, right? Those could be aspects which the organization would typically come into the picture. But responsible disclosure practices would start typically by sending emails and then sending follow-up as the situation progresses. If companies follow responsible disclosure practices, I've seen that a lot of companies, despite getting hit by cyber security attacks or data breaches, their stocks haven't gone down. Their stocks have actually gone up because they had disclosed it to the customer. One of the top banks in the US, they were hit by a data breach, and they responsibly disclosed it to their customers. Instead of their stocks tanking, their stocks actually went up. So following responsible data disclosure practices is I think is a good start.
So there are actually a couple of interesting questions on the insurance sector, which have been posted in the Q&A section regarding data breaches. Basically, if there are breaches, that result because of conduct of insurance agents, will the concerned insurance company be held liable as, I mean, whose obligation is it to notify, the data principals whose data has been breached? So there are a couple of questions around, insurance industry. Kanishk, do you have any thoughts?
See, the insurance industry would be driven by the IRDA cybersecurity guidelines. And as per the IRDA cybersecurity guidelines, if any organization gets breached, right, first they have to inform the regulator, which is the IRDA, right? And the data protection law prescribes that irrespective of what the data protection law would come into the picture, the sectoral guidelines will continue to be in the place. So particularly for banking and financial services, and if you have insurance as a segment around it, the sectoral guidelines will come into the picture. So they will have to one inform IRDI, then tell what processes they are following. The Indian IT Act will also come into the picture in this way, right? Depending on what is the level of data breach, and then the data protection law will also come into the picture. So if it is a regulated sector, there could be multiple regulators looking at it. If it is also a critical information infrastructure, CII, then the guidelines from NCII PCC, National Critical Information Protection Center, would also come into the picture. So apart from reporting it to IRDI, they will also have to inform NCII PCC and inform the CERT about it, right? So there is obviously multiple regulatory bodies in India which have to be informed. Like the CERT has to be informed within 6 hours, right? So those are going to be some additional responsibilities which are going to come in. So if an insurance company, like you've asked, gets breached, the first point of contact within 6 hours is CERT. The next point of contact they should inform is the IRDAI. The information has the prescriptive format has been specified by IRDAI that the CISO needs to disclose, and IRDAI wants the names of the CISOs which have been appointed, what steps they are taking. So for incident response, how would they be complying? So as per the IRDA cybersecurity guideline, they will have to follow up and build out their response. Right? If it is, say, a life insurance company which is under critical infrastructure, then NCI PCC will also have to be informed and what processes are being taken into consideration. Right? So these are primarily the 3 aspects, and then the data protection law will come into the picture. Depending on the breach, penalty up to 250 crores would apply, right? The severity, but organizations, particularly on the data protection bill, can challenge this. There would be a committee which would be there, and if they are not satisfied with the decision, they can go and approach the court.
Right. There's one more very interesting question, and this is for both you, Kanishk, and Abha. Although the question relates to insurance industry, I think I'll just frame it in a more generic sense. So, for instance, if there is an organization that collects personal data in physical format and that is later on digitized, how should they go about providing notice? Because it's not data that is first collected in digital format. It is personal data that is collected in a physical format and is later on digitized and therefore becomes digital personal data. So how should a notice be provided? I mean, how do at ground level, how can this be implemented?
Lagna, now this is a bit challenging, and so I had the opportunity of having discussion with some of the reach of the e-commerce platforms, and particularly where they deliver stuff to, say, the remotest of locations of the country, where it is next to impossible to sort of and there is a very interesting development there. So there was this parallel which was drawn that when the demonetization happened, we moved to a digital platform quite quickly. And if you go at the stores, even including the remote villages, you may possibility have the possible of making a digital payment. Another thing which came up was, if you look at the beauty of this law again, it says that your notice need not, it's not only English. It also says that English or one of the languages specified in the eighth schedule. With these two, I come back to your question. If you have to, now, what does this law apply to? It applies to the data that is collected, that is either in the digital form or something that is collected in a paper format, but it is likely to be digitized. How soon the notice is to be given, and how the form and mode and modality of the notice has to be executed. Now, with reference to what could be the mode and modality of the notice, in a lot of, we have seen it, you can have different modes: just in time, layered approach, paper approach, whatever that you can choose to provide these notices. What remains important is, as soon as you convert it into a digital format, you're obligated to provide notice. And therefore, I would say that at the start, when you choose or when you decide that you're going to collect this data, because see, the one who's collecting this data is surely collecting it for, say, a certain commercial reasons. So when you're choosing to collect this data, including from far-flung areas, it is important to be mindful of the fact that you're likely to go back to the same people, and you're likely to provide, and you will be required to provide a notice, because otherwise they also have the option of appointing these consent managers, and these consent managers are going to be appointed on the rules and the regulations around appointment of the consent managers will come later, and they're going to be registered, so they will have that authority, on behalf of the data principals, in order to manage the consent life cycle of the consent up till withdrawal or erasure of that personal data. The underlying point is that how should the notice be provided, and how should what methodology should be adopted, so that it can be demonstrated when required by the consent manager on behalf of the data principal, or when required by the regulatory authority, that it can be demonstrated. So again, this is somewhere where technology, with the existing technology and the technologies that possibly can be evolved in order to manage this is something that will have to be worked upon.
Right, right. And Abha, I think maybe here one of the legitimate uses would probably come into picture where, data principals voluntarily provide data in exchange for goods and services. Um, and it's not really consent that becomes, a ground for processing personal data.
Very careful. We'll have to be very careful, because again, the purpose for which the data was provided, even if it was provided voluntarily, is it compatible for the purpose for which it is being used? Now, we can also have scenarios where this data is collected, and this data is actually, let's say, a profiling activity is done in order to sell goods and services to to those data principles. Will it still, will voluntary or will legitimate users ground still hold good? That could be debatable.
Right. Um, there are a couple of questions. Um, I'm just quickly going through it. I think most of it have been answered by both Kanishk and Abha. Um, I think there are some general queries on, the marketing emails and messages that we receive from, various entities that, once, now that we have this law, now that we finally have a comprehensive data protection law, will we stop receiving these spam emails and messages that we have been getting for the past many years?
You may not stop receiving it, but you surely have the right to go back and ask them from where have they got this data. And if they're not able to explain it to you, that's clearly your breach. Report it to the board. Utilize your grievance redressal rights.
Right, right. I think most of the questions have been answered. Abha and Kanishk, if we can have your concluding thoughts and remarks on the law and whatever discussions we have had today.
Sure. So, one important aspect to understand is that there will be a specific date from which the data protection law will be applicable. There will be a timeline which will be given. So, post that, only data breaches or data moving out of companies' systems or shared with third parties, the law will apply. There'll obviously be information which has already been shared with third parties, and there is data which is lying with companies, right? So if one is thinking that you will stop receiving spam calls post the data protection law, I don't think so that is going to happen. The personal data protection bill is more about obtaining consent from users through digital formats, right, of processing of digital information. When you talk about calling, it's primarily going to be driven through the regulation which the Department of Telecom, the Telecom Regulatory Authority of India, trying to bring in, right, on calling or spam users. That will come into the picture. It's mainly around digital data, how it is getting collated, how it is getting stored, how it is getting transmitted. That's where the personal data protection law comes into the picture. So there will always be those spam calls. But if a large data fiduciary loses this data to a third party, or if the third party is going to use all of this information, they will obtain your consent, saying that this data will be used for marketing purposes, for calling you. Are you okay sharing this data? You can decide not to, consent to it, and then it is between you and the service provider. Would they allow you to obtain certain services? Would they restrict you certain access? Right, that's the key aspect that is going to change. But if people are expecting that everything is going to change, particularly around spam calls, around marketing, overnight, once the personal data protection law comes into effect, I don't think so that's going to happen.
Right, right. And any other thoughts that, final thoughts you have on the obligations of data fiduciaries, or the, interestingly, the responsibilities that have been cast on data principals under this new law?
So I think there is a question particularly around data transfers. Now, the way government has decided is they would allow data transfers to happen in the personal data protection law. But if there are countries which have been notified by the central government, right, as being unsafe, then the data would not be allowed to move to that particular country. Example, let's take Meta, Facebook, the parent company of Facebook, is setting up a data center in Pakistan. And we recently had the foreign minister of Pakistan talk about it, that Meta is now, if the data of Indian users starts to move to Pakistan, the government of India will obviously have issues around national security, safety, and they will not allow that to happen, right? So the way government is trying to regulate all of this is the government of India is trying to sign free trade agreements, and under free trade agreements they are also making data as a subject. So movement of data, particularly around cross border, is going to be one of the aspects. So India is going and signing FTAs. We have already signed a FTA in with UAE. We have signed a FTA with Australia. We are on the verge of finalizing a FTA with UK. So most of these companies would be able to move the data of Indian citizens to either these data centers which are out of these countries, which could be, say, more like a preferred list, or there would be a negative list saying that, okay, these 5, 6, 7 countries, saying China, Pakistan, where India doesn't have like great relationships, and there have been information warfare, or there are still conflicts. The law will come into the picture. It will restrict some of these companies to move data to those particular countries or locations.
Right. Abha, if we can have your, concluding thoughts on that.
So, as I see it, Lagna, there is a lot of work that has to be done by the data fiduciaries. In the sense, that this bill brings about. So far, the situation was that there used to be there are data privacy regulations in many jurisdictions, and a lot of data that gets processed in India. A lot of compliances were required in India. We did have something right from the start, right from 2010, 2011, but then that lacked enforcement. The era that we are waking up to is where enforcement is going to be heavy. The penalties, when they say up to 250 crores, it's up to for one's instance. It does not say that it will not get clubbed with any other number that is given in the act, in the schedule. And if you look at the schedule, the penalties are quite heavy, quite. Plus, we have moved in, or we have stepped in at a point where there's no we cannot go back. This is a point of no return. So we have to up ourselves with the technology that is there at the doorstep. Integration of technology is the most or super pervasive that it is not possible to escape it anymore with the sort of IoTs and all of that have come into our space. Being consent heavy, the bill is sort of relying on, and in almost all cases without exceptions, apart from the exemptions, of course, that have been provided, where all the processing that happens of the data at various levels, at various points of the data life cycle, has to be demonstrated and must have a basis. And in most of these cases, data subject must be aware of it. So while drawing up the chart of the data life cycle, where the data is sought from the customer to the point that the data is taken out of the system, the whole lot of ecosystem has to be upped, has to be prepared to be ready to handle this sort of compliance. On the other side, when we look at data principles, and I know this is going to be the most unpopular thought, the government has been mindful of the fact that, considering the compliances and considering the preparedness that the data fiduciaries or the data processors have to do in order to come at pace with the requirement of the compliances under this law, there is a safeguard that while a right is provided to the data subject, it has to be excised in all fairness, in all good faith. So if there are breaches that are suffered, or there are inconsistencies, or there are violation of the provisions that are provided in the law by the data principle, there is a likelihood that the penalties could be levied. Let us not forget that here we have there's a fundamental difference. Data principle can appoint consent manager. There is a right of nomination. So, who is acting on what basis, on what ground, and whether them exercising their rights under the act with the data fiduciary or with the board or making grievances and complaints, it has been clearly, or it has sort of been a demarcation has been provided, and this demarcation is likely to go a long way in ensuring that it is not an unnecessary burden. At the same time, the rights or the right to privacy is respected. And I go back to that opening statement, which says that the purpose of this law is to both protect the right of the individuals to, in their personal data, and the need to process this personal data for lawful purposes. So it does not stifle innovation in any manner. It does not stifle us upscaling or coming in tandem with the technology.
Right. Thank you so much, Abha, and thank you so much, Kanishk. Are there any other questions from the audience that they would like to put to the speakers today? I would request the audience to please post it in the Q&A box. I think there's one question on startups, what they need to keep in mind when they are trying to figure out a compliance program. But given how the DPDP Act has been, the provisions of the DPDP Act say that startups can be exempted. But even then, if they have to start somewhere, as they are growing, what are the key considerations that startups need to keep in mind so that maybe they want to evolve privacy by design model within the system? So some of the key points that perhaps startups need to keep in mind when they are growing, even though they may be exempted for a certain period of time.
So I think how startups define their consent mechanism is going to be very important, right? Particularly, startups would require to contact customers. Now, how do they contact customers? Will it be through email? Will it be through a voice-based systems, IVR-based systems? Will it be through a third-party call center? Will it be by their own agents? Right? All of that has to be clearly spelled out. A key issue which I saw for one startup, when the GDPR came into the picture, is that they did not have their consent mechanism clearly defined, and the regulator, which is the ICO in Europe, did not allow them to do marketing calls to some of their existing customers because they had not obtained consent from those users so that they could be contacted again for similar services or for improving services. So for startups, how do they build down their consent mechanism, their privacy policy to be compliant to this law is going to be very, very important, right? What kind of services they will be using for contacting end users? Will it be third party, right? Giving them those options, explaining why end users need to be contacted. That's it's going to be very, very important. So defining your privacy policies, obtaining consent mechanism, the whole consent management part will play a very, very important role, particularly for startups which are in the digital space and which are looking at, growing at an exponential pace, turning unicorn. So this is going to be a very important aspect. Most of the services today, whether it is insurance, we've spoken about it, are going to be through digital enabled services. So this plays an important role. So how do you manage consent, particularly around sharing data with third parties, informing users? A key aspect around it is where this has to be built in as part of their organization design. The role of the DPO. When you're trying to take an organization global, you have to comply with multiple data protection regulations. So in India, the DPO has to be local. He can't be a person sitting in the US or Europe or anywhere outside and running data protection and privacy operations. So he has to be a local person. So a global DPO cannot be appointed as a DPO in India. So they will have to have a person in India if they have to comply to the data protection law. The third element is startups are going to use a lot of plug and play services which are going to be on cloud. So aspects around security such as secure SSL, aspects around cookie management, aspects around your particularly preventing phishing attacks. So having your email security configured the right way, firewalls design, security monitoring, antivirus systems plugged up, data leakage prevention systems designed in the right way, and partnerships run with service providers who are compliant. That's going to be going to be some of the key pillars where work would require to be done. There is a follow-up question with respect to insurance companies. I think insurance companies will have a big role to play right now in terms of how they design their processes, because most of the insurance companies today use third-party service providers, obtaining consent from users, right, for allowing third parties to reach out is going to play a very important role when they are going to, implement the personal data protection bill. I'll let Abha chime in. Abha.
Very rightly pointed out, Kanish, and the sort of preparedness that we have to look at, and in terms of building the framework. Now, let's look at this. Unlike every other jurisdiction, where it says that under GDPR, you have an exemption. If you have number of, say, up from a certain number to a certain number, 250 employees or what, you may be exempted from the application or applicability of GDPR. But under the Indian Act, there is no such exemptions. So it is likely that there are just 4 people in the organization and they are processing a certain level of a certain volume or a certain sensitivity of the data. Given the risk framework, not only look at it from a compliance point that you could be penalized, but also look at it from a risk framework. So let's say, even if there is an exemption which says that you're not required to adhere to the privacy regulations, but if the risk that arises to the data subject is such that it cannot, it is irreparable and the damage cannot be reversed, does not mean that the exemption will, or does not mean that the startup would not be held accountable. So what my only thought for the startups would be that yes, it could sound overwhelming, um, given the constraints that the startup could have in terms of complying with the regulations. However, till the time the exemptions are not spelled out, and again, these exemptions are not going to be forever. There's going to be a certain framework, and we've had these concepts of sandbox, which came up in the earlier bills that we have seen. So these exemptions are going to be provided with certain preconditions. And these preconditions, to the best that I can share, are not going to be such that it doesn't matter what you do with personal data, right? There will be certain guardrails, and those guardrails will have to be respected. So what is important is that be mindful of the act, be mindful of what the act requires organizations to do. Try and build in security, privacy by design into your processes, into your products, into your services right from the start, so that it becomes easier when it comes to complying with it. Or if there are exemptions, then for that duration for which the compliance is waived off.
Right. Thank you so much, Abha. We have definitely run out of time. And just want to thank you and Kanishk for this wonderful session. And I mean, we, I mean, you have given fantastic, information and highlighted some of the key concerns and issues and what organizations need to keep in mind when they're designing compliance programs. I have definitely taken away a lot from this session, and I'm sure the audience has as well. So thank you so much, Kanishk and Abha, for taking the time out and for joining us today. And thank you everyone in the audience for joining this session on a Saturday evening. Um, yeah, I think we can conclude the session now.
Thank you, Lagna, and thank you, Kanish. Thank you, Taxmann, for hosting it.